Hello and welcome back. Matt Murphy, ABC legal analyst and homicide prosecutor who has joined us before here on KXLY Plus and on 4 News Now to look through the trial of Bryan Kohberger. Thank you so much, Matt, for being with us again today.
Happy to be here.
So we just got we call it kind of a court filing dump in our newsroom, but we got a lot more information in the last week or so. I do want to kind of bring people back, though, to the last time you and I talked, because one of the big questions I had was, do you think we're going to be getting more delays? Do you actually think that this trial is going to start in August of 2025? Here we are 6 months out, and we want to, let's just, for purposes of being able to talk about it, pretend like we will start in 6 months. What are the big takeaways? What are the big things that the prosecution and the defense are doing in these critical months?
Well, the defense, remember, has an obligation essentially to make every argument they can in order to preserve these issues on appeal. What's interesting about Idaho is that with the death penalty statutes that they have in place, this trial is actually composed of 2 parts. First is called the guilt phase, and the second is called the penalty phase. So because it's a death penalty case, these cases, they get the highest level of appellate scrutiny. And of course, we go through the Ninth Circuit out of Idaho, just like California. So this will be second guessed a million times over. So the defense lawyers have to be very careful, and they have to exhaust every possible objection they can raise and every pretrial challenge that they can. And a couple of those have been successful. You know, they brought the motion to take it out of Moscow and move it, and now it is in Boise. So they've had some success. I've said this before, I'll say it again. I think that the jury is going to be they're going to be persuaded by these facts, and I think that they're really up against it. So then the next phase will become, what is the appropriate consequence? Should he get life without parole or death? And that's, I think, what a lot of this litigation is about.
Yeah, I think people need to know too, if they didn't, Google you before they're watching this segment, you have extensive background in both homicide, death penalty cases. You've tried some of the the biggest names, Golden State Killer, Dirty John, to name just a couple of them. You have a book out right now that dives deeper into your background and just to kind of how much psychology goes into these types of cases and who these people are. So I want to bring that up and also talk to you about the importance of DNA and genetic genealogy in this case, because with that background, you've got to have some opinions about how important that is for the prosecution.
Well, the DNA evidence here is critical, and the DNA was recovered. Bryan Kohberger's DNA was found allegedly on the little snap on the sheath of what's known as a K-bar. The K-bar is probably second only to the Roman gladius as far as historical tools for stabbing people. It's a Marine Corps knife. It's a vicious thing. It's like, picture a Rambo knife, only real. Okay, so that was the murder weapon, and of course, Bryan Kohberger's DNA is allegedly on the snap portion that was left at the crime scene. So that's huge. What the defense is doing is they're challenging what is known as the familial DNA method of tracking down the DNA on the knife. And essentially what that means is with 23andMe and some of these commercial sites where you can sign up and find out how Italian you are or where your heritage is from or whatever it may be, those go into a database, and that database was utilized by law enforcement in this case, and that was used to help obtain what's known as probable cause to do the ultimate search warrant and get Bryan Kohberger's blood to get his DNA and compare it with that was found on the knife sheath. So the defense has challenged that, and familial DNA is what it's called. But it's newer in the world of forensic science, but it's not that new. It's exactly how we tracked Joseph D'Angelo. That's the Golden State Killer in my case. There was another case that I had out of Newport from the 1970s. That was my Neal case. Same exact thing. They were essentially the familial DNA found in those databases was close enough to the unknown DNA left at the murder scene that law enforcement was able to obtain a search warrant. So for those that haven't dealt with it before and those that have read the defense motions on this, it looks like it may be a real issue. if I had to guess, this is not the first time this has been argued by defense teams. It hasn't been successful yet, and I don't think it's going to be successful here. I think the DNA will be admitted against Brian Kohberger. I believe it's overwhelming, and if properly tried, I think the jury, he's presumed innocent, of course, but this evidence against him, in my view, is very, very strong.
Well, and it's interesting that you mentioned, people who've been reading through the court filings, because there are so many, Facebook groups and just online sleuths who are really invested in this case. And sometimes they're the ones who are pinging or tweeting or, posting about the latest details first. And so one of the questions that we had here in this newsroom is, from your perspective, you see a headline pop up that mentions, a potential autism spectrum diagnosis. And it was from one little line of some information from a court filing that hasn't even been made public yet, but it's already an article. What do you think we need to be paying attention to in these next 6 months? What's actually important?
Yeah. So again, the autism diagnosis really goes towards mitigation. So in California, they're called A through K factors. A being circumstances of the offense, B being other crimes of violence, and so on down the line. Almost all of them are basically like, was the defendant on drugs at the time? Were they under the influence of another person? And then there's a catch-all, section K, which is essentially any other factor that they believe mitigates the circumstances of the events. So I think that line, that's really more towards mitigation. And the argument could be made when we get to the penalty phase on this, and I think we will, that, hey, look, you've convicted him. He did it, but he's got some mental health problems, and he's somewhere on the autism spectrum. And, I think that's the direction that's going in. Whether that's successful in front of an Idaho jury, if I was in Vegas, I would say good luck with that, guys. I don't see that getting a whole lot of gristle when the chips are actually down in trial and during deliberations. The old autism diagnosis has evolved substantially over the last 25 years, and now it went from autism as a diagnosis to a spectrum, and you can be very high functioning on that spectrum. And even if you're on the spectrum, that doesn't mean that you can't form the mens rea necessary to commit a murder, doesn't mean that you can't form the mens rea necessary to commit a possible rape. And I think that that's going to be of limited value. But again, it all boils down in the penalty phase to the individual opinion of each juror. So somebody may really think that that's worth a lot of value. And what the jury is going to be tasked with doing is they're supposed to assign a weight to each factor in mitigation and each factor in aggravation. And if the aggravating factors substantially outweigh any factors that may exist in mitigation, then the death penalty can be appropriate. If they don't, then they're instructed that they're supposed to come back with life without possibility of parole. So a lot of these issues and a lot of things we're reading in court right now don't really have to do with the guilt or innocence of Brian Kohberger. They're really more geared towards the penalty phase of the case and factors that they're going to argue should be considered in mitigation.
Okay, I'm glad you brought up the jury, because that's my next question for you. I know that you've talked about this before in some podcasts, and I find it really fascinating. Jury selection, the questionnaires, what you as a prosecutor are doing when you're deciding that jury. It's almost like you're drafting, like a sports draft. I mean, it's so important. These next, when we do actually get to that jury selection, I don't know if it'll be in the next few months, but what those questions are and how people react to those questions.
Yeah, so in any high-profile case like this, you always do, and pretty much any death penalty, it's important to remember that the state or the victims are entitled to what's known as a death-qualified jury. So you don't just get random people from the community sitting on the panel, some of whom are against the death penalty. Everybody has to be able to follow Idaho law, and Idaho law says you have to be open to the possibility of imposing the death penalty. So what that tends to do is you'll get a one giant cattle call out of the venire or the jury pool, and they'll come in, and in our old courtrooms we could fit about 90 potential jurors, and everybody comes in, and then everybody gets a questionnaire. And from the questionnaires, the attorneys will often, you almost horse trade, like, hey, here are 10 people that believe that anybody who even thinks about murdering a college student should be put to death. And then you basically say, okay, I'll agree that they all go for cause, and you guys give me all the unicorn riding hippies that think that the death penalty is inappropriate. And you almost switch to the idea is to whittle it down to a pool of people that can fundamentally be fair to both sides, and that's what you want. But that fairness has to include being open-minded to the possibility of imposing death. So those questionnaires, one of the fascinating things about doing high-profile murder cases is that when you get to that questionnaire phase, oftentimes, and I guarantee this will happen to some degree in this case, you feel as a prosecutor on these things like the entire world is watching your case and everybody is hanging on every word. And like you said, there are certainly online sleuths that really are doing that. But your average juror, the people who show up for jury duty, are way more concerned about what's going on at their job, their family, their loved ones, and what's going on in their lives. And you'd be shocked how many people fill out those questionnaires and go, "Yeah, I heard about this case. I remember something about like a car," and you'll get these. It's shocking every time how disconnected they really are, oftentimes, from the world of true crime and cases like this. So in Boise, Idaho, I have every confidence they will actually be able to find a group of people that have had very little interest in the case, that can be fair to both sides, that will listen carefully to the defense, and also be willing to consider those factors in aggravation on behalf of these families. And I think everything I've seen from this judge so far has indicated that these are sober jurists who are involved in this, and they're going to do the right thing here. And remember, it's their job to ensure that the case doesn't get reversed on appeal from the Ninth Circuit. So and these things, they don't go through the normal appellate process. The normal appellate process is first they go to a district court of appeal, and then they go to the Supreme Court. For death penalty cases, they automatically get appealed, and they automatically go straight to the state Supreme Court. So these things are, and there's only, I think, 7 people on death row in the entire state of Idaho. In California, we have over 700. So it's a very, very small group, and they will take this case very seriously. So the judges want to be very, very careful. That's why that motion to change venue was granted here, because Moscow is small enough, and it's not. I don't think that judge ever thought, hey, we're not going to be able to get a fair jury here. I think it was more along the lines of, why even create the appellate issue that could potentially lead to a reversal, which means these poor family members have to go through this whole thing all over again.
Yeah, you mentioned that last time we talked. That's the worst case scenario. So
that's the worst case scenario. Yes.
As a prosecutor, you're okay with, in some cases, you're okay with the defense winning on some of those motions.
As a prosecutor, let me tell you, I can only dream of what it must be like. We're practicing in Southern California. What a Boise, Idaho jury would look like from the prosecution perspective. That's going to be a bunch of people who are probably going to be generally pro law enforcement. They're going to be appalled by what this happened. I mean, like, they're going to be normal folks. I think that you're gonna have a departure from some of the radical ideology that you encounter sometimes in Southern California. And of course, nobody on either side of the political divide has any business sitting on a jury like this. You want fair people who are open-minded to everything the defense is going to say. And I used to tell the jury, look, listen carefully to everything the defense attorney says. And remember, the prosecution gets the last word. And I would always say, and I was trained to do this, listen carefully to everything that they say. It's critically important to the constitutional rights of the defendant that you do that. But ladies and gentlemen, when I get up in my rebuttal, I will rebut every single thing that you're about to hear. That's the way you do it in the guilt phase for the prosecution. Now, penalty phase wise, it's different, because in California, the way it works is the prosecution goes, and then the defense gets the very last word. Giving the defense the greatest opportunity to kind of like, have the final say, because then if the jury still votes death, nobody can argue that the defendant did not have a fair shake in a courtroom.
Okay, final thoughts here as far as, will this trial actually start in August of this year?
You know what? Honestly, I would be surprised. I really would. Idaho has some different legal provisions that require additional notice. Like, for example, if the defense is thinking of running an alibi, they have a statutory window that they have to assert that in, and the defense did. But the last death penalty case I did, I think it took us 8 years to come to trial. So this is already, even though it seems like it's going slow for everyone, this is light speed if it goes in August. And also remember, the defense really holds an ace in their hand on cases like this because it's a death case, and because this man potentially really could be executed in the state of Idaho. It means that if the defense comes in and says, "Look, Judge, I know you gave us an additional 6 months, but I'm still not ready." There's a concept known as IAC, or ineffective assistance of counsel. And no judge on a case this serious is going to want to force a defense lawyer into trial before they're ready. So the defense really does have the ability to almost unilaterally continue this case. Whether they do or not, some of that, of course, is going to be up to Mr. Kohberger himself. He might be done sitting where he is, and he might be ready for his trial. But it's a factor in these cases, and they tend to take a long time to come to trial. And the judge, remember, is supposed to be completely unaffected by the media coverage and the intense public interest. They're not supposed to consider that in any way when they're evaluating the fairness of a proceeding against a criminal defendant, especially since in California we have a moratorium on the death penalty. Nobody thinks anybody's getting executed here again. But in Idaho, Brian Kohberger might actually be executed. So the judge has to be very, very careful how they proceed. So August, maybe. I think the defense has had enough time, but the judge is not going to want to force them into trial unless the answer ready.
All right. Matt Murphy, ABC legal analyst, with us here for 4 News Now and KXLY.com. Thank you so much.
Thank you so much for having me.